Hi guys, and welcome to another episode of Atty Vlogger, Law for the Everyday Layman. Today we'll take up part 7 on the law of sales and we'll wrap up the obligations of the vendor or the seller. We'll take up conditions and warranties, the obligation to give the buyer a right to examine the goods, the obligation to create a contract with the carrier, and the obligation to notify the buyer to insure the goods. Now, before we begin, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. And if you want to see more videos like this, please hit the subscribe button. Okay, now let's begin with a condition. A condition is a future and uncertain event, the happening of which either gives rise to rights or obligations or extinguishes rights which are already acquired. Okay, if you want to learn more about conditions, please watch my video on pure and conditional obligations. Okay, but for the purpose of law of sales, just take note that the condition here must be imposed upon the performance and not the perfection. Because if it's imposed upon the perfection, then it may prevent the existence or the rights arising from an obligation. Okay? So it has to be imposed upon the performance. And in case the party upon whom the condition is imposed fails to perform the condition, then the other party has the right to either refuse to proceed with the contract, or he can waive the condition and proceed with the contract, or if the nature of the condition is that it is a promise which will happen, then the other party can sue for breach of warranty. In which case, the injured party can either accept the goods with damages, accept and recoup in diminution or extinction of the price, refuse the goods and claim damages, or either rescind and refuse to accept the goods, or if he received it, return the goods or the price. Okay, so that's it for conditions. No, it's very easy. Just apply the rules you have learned in Oblicon. What we need to talk about are warranties. No, warranty in general is a statement or representation by a seller contemporaneously and as part of the contract with reference either to the character, to the quality, or to the title of the goods, and by which he promised to ensure certain facts are or shall be as he represents. Okay? I'm sure you've encountered warranties when you've purchased goods outside, no? It is a representation by the seller that this certain good is as I tell it to be, or it has this certain quality or character. Okay? Now, it's not only the seller who may make warranties. A buyer may also make a warranty, such as a promise to pay or any other inducement for the seller to enter into the contract with him. So what's the difference between a warranty and a condition, no? The warranty goes into performance and may even be the obligation itself. A condition, on the other hand, may go into the very existence of the obligation, such that the obligation may not even exist if the condition is not complied with. A warranty may be part of the obligation by law, even without the parties stipulating on it. But a condition must be stipulated by the parties in order for the condition to exist. And finally, the warranty is in relation to the object or the obligation of the seller as to the object, while a condition is attached to the obligation itself to deliver or transfer ownership. Okay, so there are kinds of warranties. First, we have the express warranty, which is easy enough to understand, no? Since it's express, it is really known, no? It is any affirmation of fact or promise by the seller in relation to the object which induces, okay? Induces the buyer to buy. It makes the buyer want to buy, no? And the buyer buys the goods relying on that warranty. In case of a breach of express warranty, then the buyer may claim damages. But please take note, no? Mere opinion or exaggeration in trade, that's not a warranty. Okay, it's only a mere opinion. Unless, of course, the seller is an expert upon which the buyer had to rely. Okay? Now, we'll talk more about the implied warranties because this is really the bulk of what we need to know, no? So, implied warranties are those which the law derives from the nature of the transaction or relative situation or circumstances of the parties without regard to the intent of the seller to create it. Meaning, it's a natural element of the contract, no? It is deemed incorporated into the contract even if the parties do not stipulate or write it into the contract, no? Okay? So, among the implied warranties are the right to sell, the warranty against eviction, warranty against non-apparent burdens or servitudes, warranty against hidden defects, redhibitory defects of animals, warranty as to quality, and the warranties in consumer goods under Article 68 of the Consumer Goods Act. Okay? Before I discuss each implied warranty, let me tell you first where the rules on warranty do not apply, no? There is no warranty, implied warranty, in case of as-is, where-is sales. And what is an as-is, where-is sale, no? In these kinds of sales, the buyer takes the goods in the condition in which he finds them, no? As-is, where-is. What you see is what you get, no? So, however, of course, this rule will not apply in case of liens or encumbrances which are not readily apparent upon looking upon the object, no? Or which cannot be known by a mere physical examination. Second kind of sale where there is no implied warranty, sale of second-hand goods, okay? Because they're second-hand, no? By their very nature, you cannot give implied warranties. Okay? However, these second-hand goods may be subject of express warranties, no? In case the seller so expressly gives a warranty. And finally, sale by virtue of an authority in fact or an authority in law, such as execution sale by a sheriff or public auction by a pledgee or mortgagee. Okay? In this case, the rule of caveat emptor or buyer beware will apply. Okay? Because the sheriff or the pledgee or mortgagee, they do not warrant the title of the goods, no? And they have no obligation to place the buyer in possession of the goods. As such, there is no implied warranty. Okay? Now, let's talk about the implied warranties one by one. First, we have the right to sell, no? The implied warranty that the seller has the right to sell the goods, okay? Now, this warranty of right to sell cannot be waived, okay? Because even though the law says unless the contrary is provided or there is a contrary intention, no? It cannot be waived. Why? Because the very essence of sale involves the capacity to transfer. If you remember the rule, is that the seller must have at least the right to transfer at the time of the sale. So it is required, no, that the warranty of a right to sell be incorporated into the contract. Okay? So now let's go to warranty against eviction. First, what is eviction? Eviction is a judicial process. No, it has to go through the courts where the buyer is deprived in whole or in part of the thing through a final judgment based on a right prior, okay, to the sale or an act imputable to the seller. Okay? In other words, the seller simply warrants that the buyer, if you buy this thing or this house, you will not be disturbed in the legal and peaceful possession of the property. Okay? Now, when we talk about the disturbance here, no? The disturbance here is not a mere disturbance in law. It's not a mere trespass in law. It has to be a disturbance in law. Okay? Because a mere trespass in law is like when a person simply jumps over the fence, no, of the property. And in that case, that's just a mere trespass, and there are other remedies provided in law, no, to go directly against the trespasser. What is being contemplated in the warranty against eviction is a disturbance in law, meaning that there has to be a case which is evicting the buyer from the property which he has bought from the seller, okay? And that eviction must be by virtue of a final judgment. Let's take a step back just to define final judgment and summons, because I'll be talking about that later on, no? When we say final judgment, that is a judgment which is final and executory, meaning there is the period within which to file either a motion for reconsideration, if allowed, or an appeal has already lapsed and there is no other remedy aside from equitable remedies, no, that can be allowed to review that decision, okay? Usually 15 days, no, after the expiration of that period, no, then the judgment will now be final, and that is the final judgment contemplated here in the law, okay? If you take an appeal, that should be done within the reglementary period, usually 15 days, no? The rules differ, but this is not the time nor the place for a discussion on that, okay? Now, when we talk about summons is a legal technical term, no? And summons is the mode of acquisition of jurisdiction, no, over a person. In other words, in order for a court to render a valid judgment, summons must first be served personally, and if not personally, by substituted modes of service, upon the person who is sought to be held liable as defendant or otherwise, okay? So, summons is necessary for the valid judgment because jurisdiction must be acquired over the person in order for the judgment to bind him. Okay? So, final judgment and summons. Okay, now let's go to the requisites for the application of warranty against eviction. First, the buyer must be deprived of the property whether in whole or in part. Second, the deprivation must be by virtue of final judgment. And when we say final judgment, again, the buyer here has no duty to appeal. The law says that the buyer has no duty to appeal. All the buyer has to do is prove the existence of these requisites in order to hold the seller liable for breach of warranty against eviction. Okay, again, first requisite, deprivation of the buyer of the property in whole or in part. Second, by final judgment. Third, the judgment, that final judgment, should be based on a right prior to the sale or an act imputable to the seller. Meaning that there was a right before the seller sold the thing to the buyer, no? There is a right over the property being claimed, no? Before the sale took place, okay? Then fourth, the seller must be summoned, okay? He must be summoned in the suit for eviction by the buyer, okay? Why? Because, of course, the court has to acquire jurisdiction over the seller, but really the purpose here is to enable the seller to prove his claim. Second, to avoid multiplicity of suits. And third, of course, to satisfy due process. Okay? So, the final requisite for the application of breach of warranty against eviction is that the buyer must not have waived the warranty against eviction. Let's talk about waiver for a second, no? Now, this warranty against eviction can be waived, okay? Let's be clear about that. However, the waiver of this warranty will be void if the seller was in bad faith. And how is the seller in bad faith? If the seller had knowledge of facts which would give rise to the eviction at the time of the sale, okay? And he did not disclose these facts to the buyer. However, of course, if the buyer already knew these facts giving rise to eviction, then the waiver of the warranty will be valid. Okay? Again, waiver is void if the seller is in bad faith because he knew of facts giving rise to the eviction. Okay? Now, let's talk about the two kinds of waiver. First, we have consciente. Okay? The consciente waiver is a voluntary waiver by the buyer without knowledge or assumption of the risks of eviction. Okay, it's voluntary, but the buyer did not know that there is a risk of eviction. In case the buyer is evicted, then the seller will only be bound to pay the value of the thing at the time of eviction. Okay? And please remember, if there is doubt as to what kind of waiver is given, it is presumed to be consciente. Okay? Now, let's talk about the second kind of waiver. It is called intencionada. Okay? An intencionada waiver is a waiver with the buyer's knowledge and assumption of risks of eviction. Since the buyer knew of the risks and he assumes those risks, the seller is not liable in case the buyer is evicted. This is unless, of course, the seller was in bad faith because he knew facts giving rise to the eviction and he did not disclose it to the buyer. Okay? Now, what about eviction through prescription? Can this happen? Yes, okay? A buyer may be evicted because there was previously a person occupying the property and he is about to acquire it or has acquired it through prescription. No? Again, by prescription or through the passage of time, rights may either be acquired or lost. Okay? So, a person can acquire land, no? Through prescription. That's a topic for a different time, no? So, what are the rules in case of eviction through prescription? Okay? First of all, if the adverse possession happens before the time of the sale, but the prescriptive period ends or is completed after the sale, no? After the transfer, then the seller is not liable. Okay? But the seller will be liable for breach of warranty of against eviction in case the prescriptive period was complete before the title or the property was transferred, because under this case, the deprivation of the buyer is based on a right prior to the sale or an act imputable to the seller. The seller could have fixed the prescription issue before, but he did not. He could, and it is a right also that is prior to the sale. So, it took place before the transfer. So, in this case, the seller can be held liable. Okay? Now, what if the seller does not pay his taxes, no? And because of his non-payment of taxes, the property is levied upon and sold at a public auction. Okay? The seller will be liable if the property is sold for non-payment of taxes. Okay? If this is not known by the buyer before or at the time of the sale. Of course, if the buyer knows, then the seller should not be held liable. Okay? Now, in case the property is bought at a judicial sale or an execution sale, then the seller is liable for eviction if it is found out that the seller had no right to the property after all. Okay? Now, let's talk about the liability of the seller in case of eviction. In case the buyer is evicted and the eviction is total, no? He loses the whole thing, then he can hold the seller liable for first, the value of the thing at the time of eviction. Second, the income and the fruits if he was ordered to deliver these to the victor of the suit, no? Of the winner of the suit. Third, the costs of the suit. Fourth, the expenses of the contract. And last, damages if the sale was made in bad faith. Okay? However, if the eviction is only partial, then the buyer may only claim the liability mentioned earlier except for damages, specifically value of the thing at the time of eviction, income and fruits if ordered, costs, expenses of contract, but no damages. Okay? He can do that. No, the buyer can claim that, or the buyer is granted the alternative remedy. He may choose rescission if he would not have bought the thing in case of a sale of two or more jointly. He must return the thing which he must return the thing which he has, which was given to him, or which he has received by virtue of the obligation. Okay? Again, in case of partial eviction, the buyer may choose between asking for the liability of the seller, less damages, or he may ask for rescission in case he would not have bought the thing had he known, or in case of a sale of two or more things jointly, in which case he must return what he has received by virtue of the contract. Okay? That's it for warranty against eviction. Okay? One important thing here is just remember the seller must be summoned to the case of eviction. That's a common question, okay? Now let's talk about warranty against non-apparent burdens or servitudes, okay? And what are these, no? These are encumbrances imposed upon real property for the benefit of another real property owned by another, okay? Which is not or may not be or may not have rather an external sign, meaning it's not readily apparent. You cannot see it right away. One example would be a party wall, no? It's non-apparent because when you see a wall, you do not know for certain if that is an independent wall or a party wall which is shared between two properties, okay? Some other examples of easements which are apparent, no, would be right of way, etc., no? But here, the warranty is against non-apparent burdens or servitudes. Okay, non-apparent. So, what are the requisites here, no? The real property, okay, must be encumbered with a non-apparent burden or servitude, okay, which is not mentioned in the agreement, okay? And the nature of the thing, no, is presumed that the buyer would not have bought the thing or the land or the real property had he known of the non-apparent burden or servitude, okay? So again, no, the real property is encumbered with a non-apparent burden or servitude, and the nature of the transaction or the thing is such that the buyer can be presumed to not have bought the thing had he known of the non-apparent burden or servitude. So in this case, what is the remedy of the buyer? No, he can either ask for rescission or indemnity, and the prescriptive period is 1 year from the time of delivery. Okay? Now, this will not apply, no? These rules will not apply in case the burden is apparent. Why? Then the buyer can see that the real property he is buying is subject already to a burden or easement or servitude. Okay? Second, in case the non-apparent burden or servitude is recorded in the register of property. Okay? In this case, the buyer can easily see that, hey, there is an encumbrance or servitude or burden upon the property, no? The exception here is if there is an express warranty by the seller when he says that, no, there's no hidden non-apparent burden or servitude here, okay? So that's the exception. Okay, and third, if it is mentioned in the agreement, of course, the buyer should know because it's explicitly mentioned in the agreement na, hey, there's a non-apparent burden or servitude. And fourth, this is not available in case the buyer had actual knowledge of the non-apparent burden or servitude. Okay? Now we can go to the warranty against hidden defects. Okay? In case of a warranty of hidden defects, the first thing you have to know is that this applies only to those that render the object unfit for the use intended or diminish the fitness to such an extent that the buyer would not have bought the thing if he knew of the defect or he would have given a lower price for it. Okay? That's the first, no? And second, it must be hidden. And how do we know it's hidden? Of course, it's not known, it couldn't have been known, or it couldn't be discovered by ordinary careful inspection. Okay? Third requirement for the warranty against hidden defect, no? It must exist at the time of the sale. Okay? Because if it arises after the sale, then it should not be covered. No, it must have existed at the very least, at the time of perfection of the sale. Okay? Fourth requirement for the warranty against hidden defects is that the buyer must give notice to the seller of the hidden defect within a reasonable time. Okay? He must let the seller know. Okay, and finally, the requirement to invoke this warranty is that it should be brought within 6 months from delivery. Okay, of course, let's just add one more. The warranty against hidden defects should not have been waived by the buyer. Okay, now, when is a seller not liable for damage or loss due to hidden defects, no? Of course, first, if it's not a hidden defect at all, but is rather a patent defect. If you can see the defect right away, then the buyer who buys that with a defect that is patent or readily ascertainable is stopped from questioning it. No, he knows he's buying something defective. Okay. Second, the seller will not be held liable if the hidden defect is not visible, but the buyer is an expert who should have known that the thing was subject of a hidden defect. Okay? Now, the general rule is that the seller is liable even if he is not aware of the hidden defect. Now, we are following the rule of caveat venditor here. Okay? The seller is liable even if he is not aware. He will only not be liable in the cases I previously mentioned, or if there is a stipulation exempting him from liability, and if he is not aware of any hidden defect in the thing. Okay? So let's give you. I'll give you some rules in case the object is lost due to hidden defects. Okay? In case of loss due to hidden defects and there is no waiver, okay, and the seller is aware of these hidden defects, then the seller will bear the loss. He has the obligation to return the price. He has to refund the expenses of the contract, and he will be liable for damages. Okay? Now, object is lost due to hidden defects, but the seller was not aware. Of course, he bears the loss. He must return the price and interest. He must pay the expenses of the contract, but he is not liable for damages. Okay? Now, what if there is a waiver, whether it be intentionada or consciente? No? There is a waiver and the seller is aware. And then, of course, if the seller is aware, he's in bad faith and he should be liable. Okay? And finally, what if the thing is lost? The thing has hidden defects but is lost through fortuitous event or through the fault of the buyer. No? In this case, the buyer may demand the price of the thing less you deduct the value of the thing at the time of loss. Okay? So those are the rules. And now, the remedies of the buyer in case of breach of warranty against hidden defects, no, are just two. No, you just have to remember the redhibitoria, the action redhibitoria or redhibitory action, and the action quanti minoris. No, when we talk about redhibitory action, it's simply to withdraw from the contract, no, because of the defect, no, which renders the use of the thing impossible or inconvenient, and the buyer would not have bought if he had known of the defect. Okay. As to quanti minoris, it's simply an action for the proportional reduction of the price. Okay, and these two actions must be brought within 6 months from delivery of the thing. Okay, so now let's talk about the warranty against redhibitory defect. Okay, so what are the instances when there is a redhibitory defect? First, we have the situation where expert knowledge is not sufficient to discover the defect. Second is when the veterinarian fails to discover or disclose the defect through his ignorance or his bad faith. And third, when the animal dies within 3 days from purchase in case the disease which caused death existed at the time of the contract. Okay? So first rule you have to remember is that there is no warranty against hidden defect of animals in case of animals sold at fairs, public auctions, or animals sold as condemned. In case animals are sold in case 2 or more animals rather are sold, whether for lump sum or for price per animal, then the redhibitory defect of one of those animals will only give rise to one remedy, no, which is the redhibitory action to withdraw from the contract. Okay? However, the buyer may be entitled to choose between 2 remedies in case the buyer would not have bought all those animals without the defective one, meaning that the defective animal was part of the consideration why the buyer entered into the sale, no? in which case the remedy now of the buyer is either the redhibitory action to withdraw from the contract or an action quanti minoris for proportionate reduction of the price. Either of those remedies must be brought within 40 days from delivery. Okay? Finally, for redhibitory defects, the following sales are void. Okay? First, sale of animals which have contagious diseases. And second, in case the purpose the purpose for which the animals will be used is stated and the animals are found to be unfit for the use stated, then that is also a void sale. Okay, so that's it for redhibitory defects. Now let's move on to the warranty of quality. No, warranty of quality is given as an implied warranty and the natural element of contracts in order to maintain a high business standard and to discourage unfair dealings. Okay, and under this warranty of quality, we have first the warranty of fitness and second, warranty of merchantability. When we talk about warranty of fitness, this means that the object or thing is reasonably fit for the known particular purpose for which it was acquired. Please take note, there is a particular purpose for which it is acquired. Okay? Now, the buyer must have expressly or impliedly manifested the purpose, that particular purpose for which the thing is to be used. And second, the buyer must have relied on the seller's skill or judgment, okay, in order for this kind of warranty to exist. Because the general rule is that there is no warranty for a particular purpose, okay? General rule, no implied warranty for a particular purpose except when the buyer manifests a particular purpose to which he will use the thing or when he relies on the seller's skill or judgment. Now, differentiate that from warranty of merchantability. Okay, if warranty of fitness was for a particular purpose, in warranty of merchantability, if the goods are bought by description, the seller guarantees that they are reasonably fit for the general purpose. Okay, fitness, particular purpose, merchantability, general purpose for which the goods are sold. Okay, so here in this case, especially in a case of sale by description, of course, there must be identity between what is described and what is offered, okay, as to quality and value. Okay, so that's it for the conditions and warranties, no? Let's move on to the final obligations of the seller. Okay, the third obligation, as a general rule, the buyer has the right to examine the goods before accepting them, okay, in order to determine if they conform to the contract, okay? If this right to examine is denied by the seller, then the buyer may claim the remedy of rescission. Of course, the exceptions are when the parties have stipulated that there is no need to examine or in case of sale which is COD or collect on delivery. And the exception to that exception is, of course, if there is a stipulation or if the usage of trade permits. Okay? General rule, buyer must be given a right to examine. Seller's obligation is to give that right to examine to the buyer. Okay? Seller's obligation may be dispensed with if the parties so stipulate or in case of collect on delivery sales. Okay? Next obligation of the seller is to enter into a contract with the carrier in case he is shipping the goods to the buyer, no? He must enter into a contract with the carrier on behalf of the buyer as may be reasonable under the circumstances. What if the seller fails to enter into a contract with the carrier? Then in case of loss or damage of the goods, the buyer may decline to treat delivery to carrier as delivery to buyer and hold the seller liable for damages. And the final obligation of the seller is to give notice to the buyer about the necessity to insure the goods if it is usual to insure the goods. If the seller fails to give notice to insure, then the seller bears the risk of loss or damage, except in the situation where the buyer had all the information he needs to insure the goods by himself. Okay? Again, because the only obligation of the seller in that case is just to give notice to the buyer. Hey, insure the goods. That's all he has to do. Not per se do it by himself na insure the goods. Okay? He just has to notify the buyer. And he no longer has to notify the buyer if the buyer already had all the information necessary to insure the goods. Okay? So that's it for obligations of the seller and conditions and warranties. Okay? So I hope you have picked up a thing or two, and I hope to see you in my next video on obligations of the buyer. Okay? See you soon. Bye.